Inspector General of Police issued a press statement. Although that was after they had deployed, indicating they had recovered explosives in the residence of Jimmy Wanjig'S, not from the restaurants. That is the position of the state. They've recovered explosives from the residence of Jimmy Wanjig'S. So the state, having taken that position, the highest police officer in the country, the IG, has publicly communicated, recovered this from Jimmy Wanjig'S residence. This gentleman should now be released and let Jimmy Wanjig'S and the state deal. And he's ready to deal. And as he's dealing, he has since filed High Court Constitutional Petition number E396 of 2024, in which case is going to lay bare it says filed High Court Constitutional Petition number E396 of 2024.
E396.
Yes, E396 of 2024, in which is going to lay bare the persons who planted explosives in the said motor vehicle and at its residence. There are CCTV cameras that captured officers of the state doing what is now being alleged here. He's taken the fight on.
Who planted the explosives?
The police.
In the vehicle?
Police officers planted the explosives. On that motor vehicle and at his residence. So, Your Honor, Mr. Wanjig'S, having taken control of his residence and the occurrences therein, there will be no further compelling reason to detain these two gentlemen for any further investigations. Allow the innocents to get out of the fight and allow the giants to fight like giants. And they've taken ownership. And we should not waste the court's time by involving innocent third parties in what they do not know. I do believe, Your Honor, that in light of this new information, that is publicly available, and the court should take judicial notice of the IG's statement, Mr. Wanjig'S' own public statement on this matter, there will be no further compelling reason to detain these two gentlemen. But if the only thing that will remain is to ascertain their identity, the court can direct that they appear before the investigating officer for their fingerprints to be taken and to report on a day so directed, which they will do. And then, Your Honor, my colleague Mr. Ngati will sum up. John, if I may proceed. I also support my colleagues' submissions of the application made. I also urge the court to consider that the respondents have been in custody for the last 3 days. I believe the security apparatus were doing their work, and by now they've already established the identifications of the two. So there will be no need of still holding them for a further period beyond today. Since another party has owned up on the items listed there. I this court proceed and release them forthwith with conditions that whatever is remaining for investigation be done, or they appear for any further clarification or information they need to supply. The prosecution has not said they are foreigners or illegal immigrants. Thus, they should not be held beyond today. I beseech this court to release them forthwith. That's all.
Yes, Your Honor, the state vehemently opposes that application for review of the orders given by this court this morning for the following reasons, Your Honor. Your Honor, number one, the application orally made in court is bad in law. Your Honor, it is trite law that an application submitting on matters of facts cannot emanate from the bar without an affidavit deponed as to the correctness of those facts. Your Honor, with all due respect to my senior, Mr. Willis Otieno, I'll be asking the court to disregard all submissions made from the bar on matters of facts, as there is no one who has owned those facts. There is no affidavit placed before you owning those facts, Your Honor. Your Honor, if Mr. Jimmy Wanjig'S has owned up to the ownership of the items which were recovered from the said motor vehicle, he should file an affidavit before this court, and the state will respond to that affidavit. Your Honor, as we are before you this morning, there is no new material which has been placed before you, apart from the submissions on the bar, from the bar, to warrant the court to review the orders it has given. And further, Your Honor, we note that the High Court petition E396 of 2024 has not been placed before you, either the orders or the pleadings of the same petition E396 of 2024. For the court to appreciate the facts which are attached to those pleadings, Your Honor. Your Honor, we thus urge the court to disregard the facts from the bar and to dismiss the oral application which has been made.
Yeah, just to add on that. I used to argue that that's an ambush on our part. It will have been good practice to move the court through a motion if they were seeking review of the orders before you. And this court should also note that it's a court of evidence, it's a court of law that acts on evidence, and the sensitive argument that the respondents have made raising the issue of a press statement by the IG has not been placed before this honorable court. We are unable to articulate the issues that have been mentioned one by one and verify. I've also sought to clarification from the investigating officer before this court, and it's difficult to ascertain the sentiments that have been placed before you. It will have been good practice if they document it through an affidavit so that this court can be able to verify and articulate and make its ruling accurately. With those few remarks, on behalf of the state, I oppose the application.
Your Honor, in very brief response, everything being constant, you will have paid your willingness fee on Friday. Everything being constant. But they got 3 days from that time. I would not have made an oral application at that time. But the court gave today as the date of the ruling. In between, events have occurred that this court can take judicial notice of, which is allowed. The Evidence Act allows the court to take judicial notice of judicial proceedings. It is a fact there are proceedings before the High Court concerning the petition division between Jimmy Wanjig'S and the state. They've been served, they are aware. So I'm not ambushing anybody. The DPP, the IG, the DCI are parties in petition E396 9/6 of 2024, and they have all been served. And they're aware of the orders in that court. So there's no ambush to anybody, maybe to the court itself. But this court can take judicial notice of those proceedings. The most it can do is to call for the file, which you can supply it with. So that to the extent that there are proceedings before a superior court on the question, the substance of holding these two gentlemen, I don't think only a formal application should move this court. Because all that I've said are housed in a judicial proceeding. They're not from the bar. Even what the IG said is housed. It is captured in the affidavit in petition E396. I'm just summarizing it for the court to be aware that what they are seeking is being considered elsewhere. Then secondly, Your Honor, I don't think anybody in court is disputing that these two gentlemen have now been held from Thursday, Friday, Saturday, Sunday. Today is Monday. Already they've been held for 5 days. They've been held for 5 days without a holding order. And the court has now directed them to be held for 7 days. We are simply saying regularize it. They've eaten their 5 days already. So we should only be talking of 2 days, if at all, which we are still challenging. That whatever is remaining can be done by an order directing them to attend. The court can give strict terms. It can be accompanied by a surety, the next of kin. This is an application. This ground could not have been raised before you on Friday, on Thursdays. It could have been raised before you on that day. Why? Because at that time they had not been held for 5 days. But today they've been held for 5 days without a holding order. So it's well within the purview of this honorable court to review and take into account these circumstances. It's about justice, not about semantics. Give justice to the two gentlemen who have been held now for 5 days. There's even no holding charge until today. Not even a single holding charge has been brought before you. Just general allegations made on affidavit. Even if they said we are here, we have a holding charge. And Justice Kimara talked about this issue of...
But it's not to introduce.
No, I'm just summarizing.
No, you know that issue of holding charge. It was argued before.
It was?
It was not argued before.
But this, in the review, I'm at liberty to guide, because they said I'm raising new facts, but I'm telling the court all of these are in the law. So even the question of a holding charge is in the law. None has been brought. So the circumstances, Your Honor, this is a proper and fit case that the court should now reconsider, 5 days having passed since they were arrested, events having transpired, including judicial proceedings before superior court, where there are orders that a non-custodial order should be issued for them if they are required by the state to appear. That's all.
court has other matters for consideration for hearing. So I'll deliver the ruling tomorrow morning at 9.
Much obliged.